my arrangement is right. These two 10 schedule and para 15 operate in different silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up membership of the party doesn't happen in the House. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the House. All this is outside the House. And the Speaker will have to consider, for the purposes of coming to the conclusion, whether you have voluntarily given up membership of the party, not the House. It is because of that you are disqualified. Giving up membership of the party outside the House amounts to disqualification within the House. You can't say one is different from the other. What happens in the House is unrelated to what happens outside the House. And the Election Commission can't say, I'm not concerned with any of that. Number two, Manoj, in paragraph 21B, if you vote against the whip, you will be disqualified not just under 21B, but also under 21A. Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh Rana. Let me just give you a notice briefly what it was. Of the BSP. Joint hands with the Samajwadi. Now, there were 109 members of the House. The Speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the Speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the Speaker. They were at that time not 1/3. The Speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 13 members of the Speaker. That's one part of it. My argument is completely wrong. That is unrelated to the issue of giving up membership of the House. When paragraph 3 was, before it was deleted, very interesting. It is integrally linked with the political party. And we see our compilation of statutes for this. Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. Sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes. This footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction. And you see, Mother, the correlation of this with paragraph 15, which has arisen as a result of a split in the original political party. It's 115 of their compilation. I will show that. Better Mother, we did. You can. And such group consists of not less than 1/3 of the members of such legislature party. He shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the speaker decides in the paragraph 3, Rajendra Singh Rana says, merely because you make a claim is not enough. The speaker will have to prima facie decide that there has been a split in the original political party. It's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just read 37 because that's why I wasted time with it. This is 1074 SCC model I have. In their compilation is 192. Para 37. I'm reading 36 and 37. 192 models probably. So, 219, my lords. Plus 219, they are quoting Jagdeep Singh Miller's paragraph 69. The lords, my lord, just that's in italics. Not in italics, but in indents. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that the claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said the original political party is not concerned with the split in the legislature. Just the contrary. The argument, therefore, that all of the other than 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the split in the original political party, cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part. Having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena, I am recognized by the Speaker of the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the Speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Para 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to him. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. Now, if it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do, Volume 2. First, we'll show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Shinde on the 30th of June. It is much before 19 July. At page 321. Convenience compilation, volume 2, page 321.
Yes, please.
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by your acts given up membership of the party. So, it's not a question, Malas, of removing him from the post. Now, see the letter we write to the commission at page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. Even now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, brothers, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, how is that possible to say that no, these are two different cycles? Now, and therefore, I'm saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, brothers, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph paragraph 2, where the original political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. He merges with another party, or he has another party merge with him and he forms a new party. The new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
It becomes his original political party, so he's washed his hands off the Shiv Sena. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's formed a new political party. And those who are left behind, that is, who are less than 1/3, because 2/3 makes for us, those belong to the original political. In this case, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that in the paragraph.
Thank
Now
you.
see whether what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time, but I'm not happy.
Mr. Sibal, you can conclude your argument.
No, you are in joint council.
They have argued for this.
No, that cannot be tit. No, that cannot be tit for tat. That he has taken 2 hours.
Cited certain fragments further which I.
All right, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction is. What we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it then. Now, therefore, now let's come to Muller's paragraph D. Now, I'm only saying.
Paragraph D of
Muller's. Okay. Our Mr. My colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
oh yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that the Kerala judgment, there are 2 other judgments. All right. Read the whole paragraph.
No,
Just read the whole paragraph.
Ground D of ground page 8, right?
Because and children